Good afternoon, everybody, and thank you so much for joining today. We are very fortunate to have with us Roy Kaufman from the Copyright Clearance Center. Roy is the Copyright Clearance Center's Managing Director of New Ventures. He's responsible for expanding service capabilities and oversees policy and copyright matters. Roy was formerly with John Wiley & Sons. He is also, most notably, a member of the Authors Guild and an author himself. He is editor-in-chief of an art law handbook, From Antiquities to the Internet, and author of 2 books on publishing contract law. He is also a member of the Bar of the State of New York, the Copyright and Legal Affairs Committee of the International Association of Scientific, Technical, and Medical Publishers, and he's the founding corporate secretary of Crossref and formerly chaired its legal working group. We are lucky to have Roy with us, and I'm going to let Roy start by giving us some background in what fair use is, how you look at the factors under fair use and its purpose in copyright law. Then I will jump in and talk about some of the cases involving literary works, and then we'll turn to Google Books and HathiTrust. Roy will talk about them and some of how fair use and licensing intersect, and then I'll talk briefly about the Georgia State case, and then we will open it up for questions from you guys. Okay, so I'll turn it over to Roy now.
Thank you very much, Mary, and it's a pleasure to be here. So as Mary said, I'm going to start giving kind of the basics. So I'll do the first primer, and then I'll mention cases a little bit as relevant in what I'm talking about, and then Mary will get more detailed into it. So we have people at different levels on the call, so I'm going to take it back to the very beginning, which is the U.S. Constitution. I suppose I could take it back to the U.K. Statute of Anne, but I'm not going that far. And Constitution gives Congress the power to enact laws to promote the progress of the useful arts by securing and I promise I won't read all my slides, but this is really important, by securing for a limited time to authors and inventors, that's the patent side, but authors are the copyright side, exclusive rights to their works. So that's where we start with the Constitution. And, what is this about? Well, the whole point of copyright is to reward creators, give them an economic incentive to write works. I'm going to stick here with authors since this is an Author Guild event. It's an incentive to create works, to write works, to be able to get paid for those works. And there's always a balance. Why are we doing it? We're not doing it so that people can get paid. We're doing it so that the public is enriched by the works, and that's how we do it. So to talk very briefly, so what is a copyrightable work? Again, this is the basics. So copyright, goes to works of original authorship. At the moment, they are fixed in a tangible medium of expression. So what does fixed in a tangible medium of expression mean? Means when you fix something, when you type it up, when you draw it, when it comes from your brain onto a place where someone else or something else, even a computer, can perceive it, that's when it's fixed. So an idea in your head, not fixed. An idea written down, well, you've got some copyright, although copyright doesn't actually extend to the idea, it extends to your expression. So you'll see here, these are the lists of different types of works that are covered by the Copyright Act. The most important for our discussion, of course, would be literary works, but of course these other works could be based on literary works. You can have motion pictures that are based on literary works. You can have musical works based on literary works, dramatic works, and the like. So, hang on one moment, just trying to advance the slide. So what are the rights that you get once you've fixed something in a tangible medium of expression? So now I've written my story, And I have 6 specific rights. So reproduction, that's just plain out, I can make copies. So photocopy is a reproduction. Derivative works. So this is one of the interesting things when you start getting into the nuance of fair use and when Mary starts talking about some of the cases. The right to make a derivative work is the exclusive right of a copyright holder. So the right to make a movie out of a book or a play out of a short story, that's the exclusive right. But when we start talking about fair use, there's this other concept which is called transformative use, and one of the really mushy areas of copyright law today is, how do you distinguish transformative use, which is something that weighs in favor of a fair use, versus your exclusive right to make derivative works. So what other rights do you have? Most importantly, the right to distribute the work. So again, think of a work that's unpublished. You're working on a manuscript. No one else can distribute that manuscript until you've decided to first distribute that manuscript. Now, that's a right that can be exhausted once you've sold the book. You can't stop its further redistribution, by way of example. But that is an exclusive right, and it's particularly relevant prior to publication. All right. So what's an infringement? Infringement is when someone violates one of your exclusive rights. Obviously, so an infringement is when they're doing that without your consent. If they're doing it with your consent, that's called a license, and it's not an infringement. So in the U.S., the law has changed over the years, certainly over my lifetime, and there's a bit of confusion here. But you basically have copyright protection the moment you create something, but your ability to enforce your copyrights in a U.S. court of law, first you need to have registered that work, and if you register the work prior to the infringement, you can get not just your actual damages, which might be a reasonable license fee or something that relates to your actual harm, but if you've registered before, you might be able to actually get enhanced damages and your attorney's fees back. You can also get injunctive relief, so a court order telling people to stop distributing your work or stop infringing. There are a number of course, defenses to copyright infringement. So there's copyright invalidity, independent creation, and this is interesting. It's one of the things that separates copyrights from patents. If someone patents something and then someone else without access to that creates the same invention and starts monetizing it, that second person is an infringer. Whereas in copyright, if you've actually created something substantially similar but didn't copy the first thing, that's fine. You're actually allowed to independently create. So it's not an absolute monopoly. There's another concept called de minimis copying, comes up in a few cases where you take such a small amount that the court just says, we're not going to be bothered with this, it's too small. And then there's something called fair use, and that's the topic of our discussion today. So what is fair use? So as we say here, it's an exemption from liability, and for those who are familiar with legal concepts, and sometimes people will argue this, but it is, I think, pretty well understood that it's what's called an affirmative defense. So an affirmative defense means you've committed the act, in this case infringement, but the court is going to excuse your infringement because you have an affirmative defense. This is really important. A lot of people say, well, what about my right of fair use? Well, I don't think there is a right of fair use. There's an affirmative defense. It means you have to be an infringer, and then you need to defend against that infringement under this doctrine. So we've had fair use in the U.S. law for a long time, since well before the 1976 Copyright Act. But the 1976 Copyright Act was when it was actually put in writing. It was a common law concept beforehand. And it's basically, you can read the language here on the slide, so I'm not going to read it to you. I always think of this as sort of, remember copyright is a balancing act, and particularly in the U.S., we have, First Amendment, we have free speech, And we, even those of us who, make a living as authors, make a living often commenting on other people's works and criticizing. And there's sort of a recognition under U.S. law that that should be reasonable and you shouldn't have to get permission from the copyright holder, for those types of uses. So there are 4 factors that the statute lays out, and we'll get into each of them as we go through this. But as you'll see in the highlighted, it's the purpose and character of the use. So that's focusing on the use. Then there's the nature of the copyrighted work. So that's focusing on the infringed work. Then again, the amount and substantiality of the portion used in relationship to the copyrighted work as a whole. We'll get into that. And then the effect of the market value. So the important thing to remember is these are guidelines, not rules. And every case is a little bit different. And every judge is going to read these differently. And although, as Mary may talk about when we get to the Georgia State case, there's one judge that might disagree, but one is not supposed to apply these mechanically. You're supposed to look at all of the factors. And again, so, there's sort of this favor of, criticism and commentary and news report, scholarship and teaching. But when we get into that, that doesn't mean just because it's scholarship, it's fair use. It doesn't mean just because it's teaching, it's fair use. Or just because it's criticism. Although, if you think of it logically, criticism gets a pretty big, a very big ambit, because if you imagine, if you had to go and say, I'm about to criticize your works drastically, now give me permission to publish, you can't really allow that to be prevented. So let's talk about the first factor. This is actually, over the last, I'd say, 5 to 6 years, where a lot of the action is, not because of this slide, but you'll be pretty clear when we get to the second slide. So this is looking at the use. Is it commercial or nonprofit educational? Neither of these is dispositive. As we get into the cases, there are certainly commercial infringements where they're finding fair use, and there's certainly nonprofit infringements where they don't find fair use. But you're really looking at how the work is being used by the defendant in this case, by the party claiming fair use. So again, there's no de facto rule. It's, you're going to look at it in light of these concepts, but you do say, well, it's a non-commercial entity, that might factor one might, lean in one direction or the other. The place where there's a lot of activity, some of which I think from a rights holder point of view can be somewhat frustrating, is this notion of transformative, which really comes into factor 1, purpose and character. So remember, it's the exclusive right of an author to make a derivative work. So as the author of a book, only you can authorize the film, which is, of course, highly transformative, but no one would say that that's a fair use. But basically, the sort of transformative is talking about kind of, that your use is very different from the original use of the work, and it's not sort of substituting, although now starting to blend some of the tests, not really substituting for it. There's something uniquely different about the use. Now, in 1990, when Judge Pierre Laval first wrote a law review talking about this, a law review article, it was very much the use of the work. What's happened in more recent jurisprudence is sometimes they look at not whether the work has been transformed, but whether there's a whole transformative market. And when we talk about some of the photography cases and the Google cases, you'll see how transformative use has moved from just transforming the work itself to transforming the way the work is used. And that's definitely one of the big trends. So the second factor usually doesn't carry all that much weight, but it's intended to sort of talk about, well, is the work really a highly creative work versus a not particularly creative work? For example, if the work is nonfiction, some courts will say, well, that sort of weighs in favor of fair use because it's factual. I think that's probably an overreading. As a nonfiction author, I find that deeply troubling, in fact. I think that's sort of a minority view, but there are works, if you think about sort of databases which have very low level of copyright protection in the first place, you know, arguably not, somewhere between low to none. And in a case like that, the courts are going to say, well, you know, that's really a data product. The factor would definitely weigh against the rights holder. But as versus, let's say, a painting or, you know, a song, or a work of fiction, which is highly creative. But again, I think there's more noise in the system here than there is in meat. Third factor is important. I would say it used to be more important. It used to be a general rule that, you know, if you copied the entire work, it was almost always found to be an infringement. The exception might have been sort of, you know, photography. If you're going to do a comment on a photograph, there's no way you can't copy the whole work, but certainly for textual works, that was the rule. When we talk about the Google case, you'll see that is no longer the rule. But they do look at, you know, how much of the work is being used. And again, they're looking at the original work, not the infringement. So if I take an entire book and put it into a collection of books, I've still taken an entire book. I had a case a long time ago where our work, my client's work, was pretty much entirely infringed, and they said, but it's just a small part of what we're doing. They said, yeah, but it's the entirety of our work. So again, it's your own work. And when Mary gets to the Harper and Row case, you'll get the concept of it's not just quantitative but qualitative. So if all the value is sucked out in 3 sentences, then that's all the value, and so that's going to favor the rights holder. The fourth factor is, under some case law, the most important factor, and in some cases just one of the very important factors. But really, at the end of the day, I think it's still the most important one, regardless of what the courts say. And what they're looking at there is what's the market harm of the infringement, and they'll look at both, you know, is this something that should have been paid for, or is this something that if no one pays for is going to damage the market? So it's not just the market harm of the actual activity, but sort of the ongoing market harm if this thing is found to be non-infringing. Also looks at the licensing market, which is near and dear to Copyright Clearance Center. We are a licensing organization, so it's not just, you know, the courts aren't just looking to say, well, will this affect future sales of the work adversely, but also saying, well, will this, you know, damage the licensing market? Problem with this factor is there's a bit of a circular logic to it, which is to say if something is found to be infringing, then a market will develop for it, and if something is not found to be infringing, there will not be a market that develops for it. And I'll talk about this in the context of the Google case. So with that, I think I'm going to hand over to Mary and have her talk about some of the very specific cases.
Okay, thank you, Roy. I'm just moving the computer over so I can take over the slides. Okay. So, just to summarize some of the high-level points before I go into the cases, as Roy said, the analysis is always highly fact-intensive. You have to look at every case in light of its own facts and own circumstances. And I did see that we got a lot of questions that were about, well, how much of a book can I use, how much of a manuscript, how long of a quote can I use, how much of a song, how much is too much. And what you will see as we go through these cases that it all depends. You have to look at the use and all of the factors in relation to each other. So how much you can use will depend on what kind of work it is, what the use is, what whether you're taking an important part of the whole. So we're going to look at some of the recent case law, or in some cases not that recent. I will say that when I practiced law before I came to the Authors Guild, I did sometimes for clients do something that you're not supposed to do, but as a shorthand, it's whittling down the 4 factors under recent case law. They can be often, not always, but often reduced to 2 questions. One is the work, the planning, the market for the original? And that gets to, by the market, either a licensing market or the market for the whole work. As Roy said, licensing markets are an important consideration, and sometimes when we focus on transformative use, we forget about that. The second question is, did you take more than is necessary for the purpose of the use? Okay, so I'll just leave you with those 2 questions, and now we're going to walk through some of these cases. Okay, so the first, we're going to look at a couple Supreme Court cases. There are not a lot of Supreme Court cases on copyright or fair use. There are a couple, though, that I do want to talk about today that deal directly with how courts should be looking at the factors. So the Harper and Roe v. Nation case goes back to 1985. This involves an autobiography by Gerald Ford that Harper and Roe was about to publish. It had not been published yet. Harper and Roe had sold the right to Time magazine to publish a 7,500-word excerpt from the book. In the interim, before Time was able to do that, Nation Enterprises, Nation magazine, got a hold of a copy of the manuscript. And Victor Navasky, who's actually on our council, wonderful gentleman, he wrote an article based on the manuscript that included some quotes from the book. And he did it very hurriedly because one of the things they were trying to do was scoop the Time publication. He took quotes, the article took quotes, largely around the parts of the book that dealt with Ford's pardoning Nixon. Now, as a colleague of mine said the other day, Ford did not have the most interesting life, perhaps, and this pardoning of Nixon was considered part of the book. So the court looked at this and said, with respect to the first factor, it agreed with the Nation that, yes, the purpose was newsworthy, and this was something of interest to the American public as a whole. But it said it was scooped, and that there is no right to make news. In other words, there is, even though this was newsworthy, that did not actually make it necessarily a fair use. It also said that it was a commercial use, clearly commercial. They were trying to make money here. On the third factor, this is the most interesting part of the case, which this case is often cited for, said even though the Nation article is only 2,500 words, only about 400 words were taken literally from the book, so it wasn't a large quantity, it wasn't a huge quotation from the book, but it was the heart of the book. As the court said, it was the most interesting and moving parts of the book. And as to the fourth factor, Time magazine had canceled the licensing for the 7,500-word excerpt. They were going to pay $25,000, and they revoked that. So the court said there actually was harm, and they found that this was not fair. So as you can see, you can take a very small quote, and it can actually be not fair use, relative to the work as a whole, that is. The next case I want to talk about is a more recent Supreme Court case on fair use, Campbell v. Acuff-Rose. This involves a parody of the song "Oh Pretty Woman," the Roy Orbison song, which I'm sure you all know. The Group 2 Live Crew, the rock group 2 Live Crew, did a parody of that song, a version using the same tune and many similar lyrics. And I think the name of the song was Big Fat Hairy Woman, something like that, or Ugly Woman, and it was set to similar music, but a rap beat. In this case, the 2 Live Crew had taken a lot of the song, and the plaintiffs here, representing the Roy Orbison song, alleged that the taking was too much, and it was a commercial use. Until this case, whether the use was commercial had been a very important factor. The cases had largely said, since Harper and Row, had become the most important factor. And the Supreme Court said, no, actually, whether the use is commercial should not be the prevailing factor here. The court said that the use here was transformative. Roy talked a little bit about that, how that, under the first factor, has really become the most dominant analysis. Has the new use transformed the original work in a way that adds new expression or meaning? And the court here said yes. This is a parody. A parody necessarily has to mimic the original. It has to take enough to conjure up the original, so the Roy Orbison song, because you have to know that's what it's referring to. And the court said that the more transformative the subsequent uses under this first factor, the less weight will be given to the remaining 3 factors. And as you'll see as we go through some of these other cases, particularly the Google Books case and Georgia State, this has been taken perhaps a little too literally, in my view, by subsequent courts and decisions, so that in some cases it feels like whether the use is transformative becomes the only factor. In terms of whether under the 4th factor, the court found that the 2 Live Crew song was not going to supplant the market for the original, for the Roy Orbison song. Now, of course, it goes without saying, I think most people would agree that few people were going to go out and buy the 2 Live Crew song instead of Oh Pretty Woman. But the question here is, was there a licensing market for that? Is that a right that should have belonged to the original songwriter to license a new use of that song? Now, in the case of parody, parody has always had a very special place in fair use law and in free speech generally, because it's deemed that a parody, not that many copyright owners are dying to license out the right to create critical parodies of their works, right? So courts have understood that parodies should be protected as valuable free speech, and I think that influenced this case a great deal. The court, I do want to note one more thing. The court did say that a parody, although it has to mimic the original, taking too much can actually defeat fair use. And the court remanded the case for a finding of whether too much was taken. I'm going to move on to the next case. We're now moving mainly to, these are, as I said, cases involving literary works. They are mainly in the Second Circuit. Most of them have come out of New York, which is, for obvious reasons, where the publishing industry has largely been based. So in the Salinger v. Random House case, this goes back to 1987, the author Ian Hamilton wanted to do a biography of J.D. Salinger. Salinger, as you probably know, was notoriously reclusive and private. He did not want to work with this author on an authorized biography, so he refused. But Hamilton went ahead with his biography, and he found some unpublished letters in archives and academic libraries, and he used a number of these unpublished letters written by Salinger. Salinger had given them to the archives, but expressly said that they were not allowed to be copied. So Hamilton nevertheless went ahead, used some of the letters in his book, and Salinger brought a lawsuit. The court in this case said that this was not fair use. Even though the number of words taken was not huge in comparison to the letters as a whole, they were deemed the backbone of the biography. In other words, the court said that these letters were a means of capitalizing on interest in Salinger, on interest in the letters, rather than on providing a critical study of the author. So really, the court focused on the use here. Was the use simply to provide a newsworthy, historical analysis of Salinger, or was it taking unpublished work and bringing it into public dissemination? So as you see, this is another case we're taking, like the Harper and Row case, taking an unpublished work and making it public. There are special protections for unpublished works under the second factor. Courts will look at that. So here again, the court said this is not fair use. Okay, on the other hand, here we have a 1991 case, also in the Second Circuit, involving use of quotations from unpublished letters. Again, the author, Margaret Walker, she wrote a biography of Richard Wright, and she quoted from 6 unpublished letters of his and 10 unpublished journal entries. And Wright, at that point, had passed away. His widow sued. The court said that this was fair use. It said that here the use was informational. It was, the letters were being used in the context of the work as a whole. The work was not being structured around the letters. They were being used for illustration of points being made by the author, and only 1% of the letters as a whole were copied. So they said it was fair use. So you can see how it's very, very fact-specific, whether or not courts will find fair use, and it's not always so easy to determine in advance how a court is going to weigh the various factors, unfortunately. Now I'm going to turn to another parody use. I'm sure you're all familiar with Gone with the Wind. I will say back when I was in a big law firm and taught fair use and copyright to the junior associates, I remember being astounded when I was talking about this case and none of the junior associates knew of the book Gone with the Wind. It was at one point the best-selling book in America, with the exception of the all-time best-selling, with the exception of the Bible. So, Gone with the Wind, the rights were owned by SunTrust Bank, and a book was written by Alice Randall called The Wind Done Gone. This was, interestingly, the case was in 2001. The Wind Done Gone tells the story, the same story that's told in Gone with the Wind, which is told from the point of view of Scarlett O'Hara. The Wind Done Gone tells the same story, or many of the same events, from the perspective of one of Scarlett O'Hara's slaves, and actually her half-sister, through her nanny and father, Sinira, and goes through the same time period and events. And this went up to the 11th Circuit. This is not a Second Circuit case. The 11th Circuit is in Georgia, Florida. The court said that it was fair use. And I think at the time, many of us were surprised by this decision, though ultimately I think it was a good decision. Here they said that The Wind Done Gone was in fact a parody. It commented and criticized the original work, Gone with the Wind, and created a new artistic work. It criticized Gone with the Wind's depiction of slavery and race relations in antebellum South, and I think also was, in my view, it was parodying the place that Gone with the Wind has had in the American literary imagination. It went beyond just criticizing the book. But in any event, the court said it was a parody of the original. It was transformative. Under the first factor, it said, yes, it's commercial, but it significantly transformed the original work. It added significant new expression and meaning to Gone with the Wind, and in turning it from a third-person epic to the first-person diary of, or memoir of Salinger. The court then looked at the second factor and gave it little weight. As Roy pointed out, that factor is given not much weight, never really has been, but in the transformative use context, it's given actually less and less weight. You know, here it was obviously a work of fiction, and the court said, well, it's a work of fiction, but parodies almost invariably copy publicly known expressive works or creative works. In terms of the third factor, the court said, well, yes, a lot's been taken, but no more than was necessary for the parody, that Randall had created her own story. And for the fourth factor, the court just said that the SunTrust had failed to show that there would be an injurious effect on the market by displacing sales. So that was really a question of what kind of evidence had been provided. Now, I'm going to go through all these cases, and just if you have questions, save them for the end, because it's easier to manage in this format. Just write them down, and we can get to them later. Now I'm going to move to another case where a similar type of situation where a kind of a sequel in this case to a famous book, in this case was Catcher in the Rye by Salinger. A Swedish writer wrote a book based on The Catcher in the Rye, but 60 years later, as the title says. The title is, I don't know if you can read the whole thing, it's 60 years later, Coming Through the Rye. Written under a pseudonym John David California, which I think is kind of funny, actually. So the main character in 60 Years Later is Mr. C, and it's modeled very intentionally on Houghton Caulfield, the main character in Catcher in the Rye. Salinger State sued here, and the author claims, oh, well, this was a parody, trying to liken it to the Wind Done Gone case. And that argument was rejected by the court. The court said that fair use would not succeed as a defense, was not likely to have granted a preliminary injunction. And if you were, you know, around and following these things at the time, you might remember that it was labeled as a banned book, and that this was, you know, deemed a bad thing because the book was being banned. It was, in fact, its publication enjoined in the United States. The Second Circuit looked at the case and said that it agreed with the fair use analysis and said, in fact, this is taking too much. And in terms of the fourth factor, and it didn't believe that it was a parody. It saw this book as a sequel. The 60 years later, took the character Houghton Caulfield and just placed him in the present day 6 years later without adding anything new to the character. The character's personality remained intact. And so it didn't buy the parody argument. It said it took too much. It took the character as a whole. And here the court said it won't supplant the market for Catcher in the Rye, but it will supplant the market for sequels, which the court correctly said belong to the the copyright owner of the original. As you see, I'm showing you cases where the courts are finding, you know, the facts may just differ a little bit and the court finds differently. Okay, so now moving on to a different type of situation, books about TV shows and movies, and book collections. Here is the Seinfeld Aptitude Test, or SAT. This was a book of basically aptitude test quizzes about all the various Seinfeld episodes, 84 Seinfeld episodes in total. Some of the questions used actual dialogue from the show, and many of the questions did, and it was based on the events and characters from the Seinfeld television series. Here the court said this is not fair use. Again, this is a licensing market that belongs to the Seinfeld television series. Copyright owners, Castle Rock Entertainment. It should have been licensed. And again, it said too much was taken. The publisher should have gotten a license. Okay, here is in Warner Brothers VRDR books. The Harry Potter lexicon was published, written by Steve Vander Ark, a big fan of Harry Potter. There's an encyclopedia of all 7 of the Harry Potter books. It listed out and defined the characters, places, spells, creatures, all the magical devices, and had a whole timeline of events. J.K. Rowling had stated previously that she had intended to publish her own companion books and lexicons for the Harry Potter series. So in this case, the court also said this is not fair use. This was a right that belonged to J.K. Rowling and her publishers. The court said too much was quoted from the original books. There was not enough commentary. They did find it was slightly transformative, and I will say this is the only case where a court has said that a use had some transformative value and was not fair use. So that will tell you a little bit about how important the transformative use factor is in these cases. I have a quote from J.K. Rowling because I thought this was, you know, from an author's perspective, I think this is important to see why she brought this case. And she did say that during this case she was so upset by it she couldn't write. So she wasn't dying to litigate here. But she felt like she had to bring this case to uphold the right of authors everywhere. She said the book took an enormous amount of her work, added virtually no original commentary. And even though some books have been published which offer original insights into the world of Harry Potter, the lexicon just is not one of them. Now, the defendant here thought about appealing the case, did not. This never went up to the Second Circuit. Instead, he wrote a new version of the book with less quotation and more commentary, and that actually won a J.K. Rowling Fan Award, and she later said that she consults the lexicon now herself when she can't remember various things from the book. Graham Archives v. DK relates to the use of images in books. And I know this is something that as authors you often come up against. You want to use images, and is it fair use? Can I use them? I can't clear the rights. Maybe it's an old photograph. I don't even know how to find the copyright owner. In this case, there were original poster designs that were done for the tours of the Grateful Dead. And the book here is about the Grateful Dead. It was a biography containing the timeline, and the timeline had thumbnail reproductions of all these concert posters. So the copyright owner in the posters brought this infringement action, and here, surprisingly, the court found fair use. The posters were copied in their entirety. the court said you have to copy the entirety of a poster of an image. You can't use half of it or a third of it. It wouldn't conjure up the original. Nobody would know what you're looking at. And the court said that the use was so transformatively different from the original purpose, which was advertising a concert, so it did not exploit the expressive value of the images. And further, it said even though they used the whole work, they were reduced in size. And they found no harm to sale of the original work. But here's the case where you have to question, well, what about the licensing market? They had asked for a license and failed to negotiate a license and instead just went ahead and used them. And this could be seen as a licensing market that belongs to the copyright owner. In any event, this is a Second Circuit case. It's now the law. I'm just going to speed through the rest of these. This is a case where a photograph, an unpublished photograph, again, note the importance of unpublished, was found and stolen, purloined, in fact. This is a couple, both celebrities. They were married. They didn't want anyone to know about it. Their chauffeur found a flash drive in their car a year later with these pictures, sold them. They were published in the Spanish language magazine, and the magazine argued this is fair use, this is newsworthy. The court said no. In this case, these were unpublished, and fair use has bounds. This was commercial. Even though it's news reporting, there's no per se public interest in these kind of photos. And in fact, these are worth a lot of money in the journalism field, and so they saw market harm. Okay, so that's it for the cases. I'm now going to turn it back to Roy to talk about the How Do You Trust and Google Books.
Okay, thank you, Mary. That was great. In the interest of time, I'm going to go relatively quickly through these cases, which certainly, if you're interested in more detail, there's a lot online you can find talking about these two cases. So both of these were Authors Guild cases, which were heard in the Second Circuit. So that's, again, the court where, among other district courts, New York cases go up. And both of them were under what we would call a common nucleus of operative facts, which was a project that Google undertook in conjunction with a bunch of academic libraries to essentially copy everything in the library. A little bit of a couple disclaimers in two different directions. I was working at the time of the Authors Guild v. Google case was brought. I was working for a plaintiff publisher, so one of the publishers who sued Google. But anything I say, of course, is my own opinion and not theirs. So what happened in those cases was Google thought, hey, this would be great, let's digitize everything. They actually made the announcement the day that they went live with a different mass digitization project, which is called the Google Publisher Project, which I had actually worked on the license for with Google, where Google was, with the consent of the rights holders, making books searchable and giving more than snippets, giving a couple pages under license. So when I woke up the morning that program went live and read in the paper that Google was about to digitize everything in the libraries, I thought, hey, this is great. My company owns a lot of books that are in those libraries, and wouldn't it be fabulous if we just add this to the agreement we just negotiated and people can get a couple pages of it because it's backlist and we've already given them the front list, and isn't this wonderful? And when we wrote to them and said, hey, are we just going to add this to the existing agreement? They said, no, we don't need any rights to do this. The reason I'm telling you this is because my view on this case is, although you know, because in every case you have to have a quote-unquote winner and loser. I don't think anyone won this case. I think Google didn't win and the public didn't win. Certainly the Authors Guild and the publishers didn't win. So basically this mass digitization, this copying of everything in the library, went up to the Second Circuit twice. Once was against the Houghton Trust, which was an organization of 80 college, university, and nonprofit libraries that were supplying the books to Google to be digitized. And ultimately, the courts found that in that case, the digitization was fair use. The argument was that they were creating the copying was done so that there could be searching, which was transformative, to allow library patrons with print disabilities to have access to the works, and also to provide for replacement copies. Now, the Copyright Act actually has language about replacement copies, but nonetheless, there was also a fair use argument there. And again, the court found that these were transformative, and because, as Mary said, somehow once you waive this transformative, which isn't even in the first factor but has been read into the first factor, and now the transformative want has been waived, and therefore the rights holders are about to lose. You know what's coming. So then after the Houghton Trust was the main case against Google, and there facts that they looked at were a little different. So first of all, they looked at when you search the Google Books database, you only get what's called a snippet. And remember, I said, this is one of the places people lost, because you can only get a snippet because they would rather litigate than work it out. But that was Google's decision. That there's certain amounts that are blacked out, so you can never really replace the whole book. There's an opt-out process at the title level. Now, historically, copyright is an opt-in, not an opt-out doctrine, but that's been sort of shifting. The search function was deemed transformative because they looked at an example of something which is called text mining, where you can, if you did some nonprofit social science research using the database in a certain way, that would probably be fair use, and therefore the scanning was fair use. So there's a bunch of different things in there as to why the court declared it to be fair use. I mean, I don't think the case was necessarily correctly decided. Interestingly, since it was the judge who sort of created the transformative concept, Mary's going to talk about the GSU case. He actually put in a footnote saying to the GSU judge, on the other hand, you've got everything else wrong when they looked at the factor of commercial versus non-commercial, and in this case you decide, well, yes, it's commercial because Google's commercial, but what they're doing, can be used as fair use. And there's a lot in this case, I will say, that the judge said about because Google is doing it specifically this way, it's fair use, implying that if Google does other things like sell ads or other things on the content, they probably would be infringing and be outside the bounds. Court also dropped this footnote that said, and by the way, just because you're non-commercial, and he didn't actually call out the Georgia State judge, but almost called out the Georgia State judge, that just because it's non-commercial doesn't mean it's non-infringing and that it's fair use. So anyway, these are very lengthy decisions. They're very commonly commented on. I'm happy to take questions in the Q&A period. Definitely don't think the judge got these right, and one of the things that the judge looked at or the judges looked at in both cases was the licensing market, and they actually mentioned CCC and say, well, CCC doesn't license this, and therefore, that's somehow evidence of market harm. And I thought, well, we're not going to license it because there's someone infringing, and unless you declare it's an infringement, they're not going to take a license. And, as the guy, managing director of New Ventures, who would be responsible for developing this business, I'm not going to develop the business on that basis, So this, again, gets into that difficult cyclical knowledge and circular reasoning of the fourth factor. So with that, and in the interest of time, I'm going to stop and pass it back to Mary.
Okay, thank you, Roy. So I'll just talk briefly about the Georgia State case, which CCC has some involvement in. So I will talk about, thank you, Roy's advancing the slide. So Georgia State, I do just want to say one thing about the Google Books case, because it is now the law. It is the Second Circuit law, and until the Supreme Court did not take the case, the way that we are, I mean, it has been interpreted is very narrowly, and Judge LaValle has spoken a number of times in different places, stressing the fact that he intended this decision to be very narrow on the facts, because our fear was that everyone would take this decision and say, okay, well, it's perfectly legal now to scan whatever books I want to, as long as I only make snippets available to the public. And in fact, other people have started scanning entire collections, and as we fear, this has become a practice, but LaValle pointed out that you had to have really good security, which was something we were concerned about. If you don't have good security, then the books just get out on the internet. And also that the snippets, you know, had to be kept relatively short. So, but it is possible that people will take this case, and in fact, we know there are some entities that are already have plans to do this and have done it, to say, yes, we can scan books, and in fact, we can probably show the whole book in certain situations. So it's what we call in law the slippery slope theory, you know, as plaintiffs, you can't litigate everything. It's simply unaffordable. So how much security you need is still an open question. How much you can display is still an open question. Okay, Georgia State, I won't go into this in any detail. We did file amicus briefs at two different stages in this, we meaning the Authors Guild. It's been going back and forth. It started in the district court in Georgia in 2008. This is Cambridge University Press, Oxford University Press, and Sage brought a copyright infringement action against Georgia State with respect to its practices for electronic course packs. Now, before e-reserve or electronic course packs, universities, as you probably recall, would make hard copy course packs. So where professors didn't want to use a whole book, they would assign a chapter of this book, a chapter of that book. The university would have to clear rights for those excerpts, and photocopy shops would make these course packs, but the uses were licensed. And I believe CCC was involved in this, is involved in this kind of licensing, right?
Yeah, it still goes on today, and what we've experienced is basically a substitution from when things were photocopied in print by a course pack provider, license fees were paid, and what's happened, including in the GSU case, is when they stop making the print ones and just start giving electronic access, they stop paying permission fees, and that's really what the case was about.
Right, exactly. So here we've got a move from hard copy course packs to the electronic course packs. The district court, the first thing they did was limit this case to a 9-month period in 2009. And only would look at uses made during that time, whereas the plaintiffs were saying the problem was the policy with GSU and how they looked at fair use, the instruction or lack of instruction they were giving professors, and that the pervasive use was causing harm through the policy. But the court said, no, we're only going to look at these, I think it was 75 uses made in 2009, and found that all but 5 of them were fair use. So it first said, under the first factor, GSU is a nonprofit, so the first factor weighs in its favor. It's also, this is an educational use, it's educational. First factor weighs in its favor. It did say it's not a transformative use, taking excerpts, thank goodness. Transformative use wasn't taken that far, but nevertheless said this factor weighs in its favor. Now, of course, there is, as we all know, there is no per se exception in the copyright for educational use. Why? Because many books are written for educational use, and you would have no market for those books, so nobody would be able to write them or publish them commercially. You'd have no market, right? So the court sort of ignores that, though, even though there's prior case law instructing on the fact that you should not take educational use as determinative. The court then said that, well, you shouldn't have bright line restrictions, but for purposes of convenience, we're going to say that wherever only 10% or less of a book is taken, in terms of the amount taken, the third factor, we're going to say that that weighs in favor of fair use. That's basically it, the fair use, or if it's only one chapter, if there's more than 10 chapters in the book. Now, I won't go into this first district court decision in any more detail. Today, it did go up to the 11th Circuit. The 11th Circuit reversed and remanded to the district court with instruction to look at some of these factors differently. First, it said that the mechanical way the district court added up the factors and giving equal weight to all four of them was not proper. It also said this 10% or one chapter rule, there aren't rules like that, per se rules like that in fair use. Can't use that. You have to look at the amount taken in light of the educational purpose of the use and the threat of market substitution. It also said that because the uses were not transformative, the district court should have given more weight to the fourth factor. And it did say that under the first factor, jumping back up to the first factor, that the nonprofit educational use for teaching did mean that the first factor weighed in favor of fair use, even though the uses weren't transformative, but did say not all informational or educational uses weigh in favor of fair use. So that was good language. And so with these, I do want to note one more thing. It did, though, say, because of course the plaintiffs argued, well, there's case law saying that for hard copy course packs, you have to license these. It's not fair use. So that should be true in the digital sphere. And the court said, well, that doctrine of media neutrality doesn't apply to fair use. So goes back down to the district court. The district court basically says, oh, we were right. Doesn't really change its analysis, but gives some kind of, deference, at least in words, to the 11th Circuit. Basically, though, finds the same 70 works are still fair use, provides a new mathematical formulation. Of most concern to us, and I really hope, this is in front of the 11th Circuit again, I really, really very much hope that the 11th Circuit takes this very seriously. We argue this in our brief. Looking at the market harm, the district court insisted on looking at this as a damages case. The fourth factor says you have to look at the effect on the market if the use becomes widespread and unrestricted. Because in fair use cases, you're making a rule of law. You're not, even though they're fact-specific, you're basically saying, okay, in this instance, it's fair use, so it's fair use everywhere else. So you really need to be looking at what happens when all of these e-course packs, electronic course packs, are fair use. There is no longer a market for excerpt use unless the excerpts are particularly long. That should be the way this fourth factor is analyzed under all the existing case law and the Supreme Court precedent. For some reason, the 11th Circuit didn't really hammer on that in its earlier decision, and the district court just dug in on this on remand and basically said, well, first, if there wasn't a license available from CCC in 2009, then there was there couldn't be market harm because there was no alternative market. Then it said, well, even if there was a license available, in some cases there were licenses available for electronic use from the publisher, and again, we're talking about licenses solely for e-course packs. The licenses were already available for hard copy, but the district court said, no, it has to be a reasonably efficient availability, reasonably priced, convenient access. In other words, you had to have a digital license available for there to be market harm. But even if there was such a license available and the plaintiffs weren't making much money, the court said, oh, that's not really much market harm, just a couple $1,000s. That's not a big deal. Okay, that drives me up the wall because, as we all know, publishing is a penny business. Little amounts add up, and of course, if every university in the country is doing this, it adds up to even more, and it comes out of authors' pockets because authors get, have always gotten royalties from these course packs when their books are used in excerpt form in the classroom. So it's back up to the 11th Circuit, and knock on wood, let's hope they see the light. A big issue in this case is attorney's fees. The district court has twice awarded attorney's fees to Georgia State, meaning that the plaintiffs have to pay not only their own attorney's fees, but also Georgia State. And that, to me, is just outrageous because this is, first of all, even if you find fair use, it's a very, very close case. So we're hoping and assuming that the court will overturn the attorney's fees award too. So I think we are done with our presentation part. We'll now turn to some questions. If you haven't already emailed your questions in or added them to the comment section, I should say, please do so. We did get some questions in advance, and Moira and I will try to answer those. Maybe starting with the ones that we got in advance. So I'm first going to respond to one of the first questions that I see actually here on the screen, because this is a very, very detailed, specific question about using letters from a convicted killer. And saying that you'd only use about 500 words from these letters that are unpublished. This is the type of question, because fair use is so fact-specific, that we can't really answer in the abstract. So I'm going to ask you, if you're an Authors Guild member, to please email me at staff@authorsguild.org. staff@authorsguild.org, and I will walk through this with you.
Yeah, I will say, you know, when you're talking about unpublished letters by a famous person, as we saw in some of the cases Mary talked about, these can be very fact-dependent. And, you know, when I worked at Wiley, I had at least 2 manuscripts where this issue of unpublished works by very famous people came up. And I got to tell you, I always felt that it was my job to try to get the work published, really, you know, not be overly cautious, because if something needed to be done, it needed to be done. But I really encouraged the manuscript authors, instead of quoting, you know, I'll give you an example, I'm going to ride my red jalopy there on July 3rd, just say, in the letter, you know, the author discussed their red jalopy and that they were going to go on July 3rd. Now, paraphrasing isn't as powerful, but facts are not protected by copyright. And particularly, you know, the question, you know, and you can have this discussion with Mary, in both of these cases, I had lawyers on the other side ready to pounce. So, you know, these are very difficult issues.
Let me just add one thing to that. Because in the Salinger case, the author of the Salinger biography, he did paraphrase, because he had sent the quotes to Salinger, who said, no, you can't use those. So he paraphrased, and that wasn't enough. It was still deemed that he took too much. So it just depends. And this reminds me of a point that we haven't really talked about, and that is that in any fair use analysis, you look at the law, you know, how a court would come out, but you also have to do a separate risk assessment, and that is, how likely is the copyright owner to sue? If you are using Salinger's work, his estate is known to be litigious, very private, you're going to have a much, much higher bar to fair use, because you're much more likely to be sued, right? one of our council members was using a T.S. Eliot poem in his most recent book. It's a long poem. He was only using a couple stanzas. The publisher, I said, well, it's fair use. It's not, you're not taking too much, you know, just under a legal perspective, but the Eliot estate is known to be litigious, so the publisher said, we want you to get a license, which he did.
Yeah.
So you do have to think about that.
Okay, so I'm looking at some of the other questions that were provided. I like this one. If the author is listed as copyright holder, can he or she give permission? So the answer is, well, probably if they own the copyright. And so I don't mean to be too flip there. You know, you need permission from the copyright holder, or the exclusive licensor, you know, someone who has the right to give you permission. So typically, the first place you would go to figure out who owns the copyright is the copyright notice. And if the copyright notice is in the author's name, there's a reasonable assumption that the copyright holder is the author, but the author may have assigned the copyright to someone else.
Yeah, and let me just jump in here, because it's not actually in trade publishing. The standard is, in academic publishing, often authors do assign their rights, which we actually take issue with, but in trade publishing, it's always a license to the publisher. The author is always listed as the copyright owner. However, if the publisher still has the rights to the book, the publisher needs to grant the rights.
Right.
Because they actually have those rights under license. But if you go to the author will forward it to his or her agent or directly to the publisher.
Yeah. So that's where I was heading.
Yeah, okay.
So it doesn't necessarily mean that the author has those rights, but certainly if the author gives you permission, often you'll ask for a warranty, particularly if you're paying for it, and you get a warranty, and that'll give you some degree of protection. So, Mary, you want to take the next one?
Yeah, so I'm going to take this question. The question is, if I'm editing an anthology of advice, is it legal for me to publish 74 words or less of advice that has already been quoted from experts in other publications? Meaning, if something's already been used, can I assume it's fair use? So I have a couple different thoughts about this. First of all, the 74 words, how much of the original is it? For what purpose are you using those 74 words? Are they illustrative, or are you using them for their expressive content? Probably not the latter. So it sort of depends. This is, though, where I would also look at risk, right? Just a minute ago mentioned risk. So if other people are extensively quoting this and nobody's been sued, and 70 words is not that much, I would assume you're probably okay. But I would provide attribution, and that in any risk assessment is often a very important thing, although it is not part of our fair use law in this country. It is something that matters a lot to copyright owners, and if you provide attribution, they are much less likely to feel like they've been ripped off, but rather you're saying, oh, this is, you know, you're giving them credit for the idea and the words. I was at a conference with the Copyright Society this past weekend where an Israeli lawyer talked about their new fair use law. And interestingly enough, they've adopted the same 4 factors plus the right of attribution. And that is because other countries have something called moral rights, which we don't. And if you're interested in that, go on our website and look at our recent blogs on moral rights. Do you want to take another one?
Yeah, sure. I'll take one that was emailed. So someone is preparing homilies based on St. Mark's Gospel, and can someone use them based on fair use? So again, the homilies are creative works, so presumably you're writing something new and something expressive, and you would therefore own the copyright. Again, St. Mark's Gospel is in the public domain, and certainly anyone else can create homilies based on St. Mark's Gospel, and many people have. So the question is, can someone else use them based on fair use? And again, it gets back to the 4 factors. So what kind of use are we talking about? Are they taking a small piece of what you've written to comment on, the scriptural analysis, the liturgical value? Are they just using it because they're, recopying it and selling it? Well, obviously, that's more of a commercial use, something that interferes with your copyright. So again, anytime you own something that's copyrightable, someone can make a use of it and defend fair use, depending on how those factors apply. Mary, why don't I give you a next one?
Okay, so let me take this one that was just emailed in. What about fair use of slave narratives that have been digitized by universities or religious organizations whose clergy actually recorded the narratives in the late 1800s? Well, this is a really easy question because those are all in the public domain. So copyright, once something's in the public domain, it's just free for anybody to use. You don't have to consider fair use. The current law is life plus 70 years, and before 1976, the laws were different, but essentially nothing before 1923 in this country is in the public domain. Everything before 1923. Sorry, I have a cold, foggy head. I said that wrong. Everything published in the U.S. before 1923 is in the public domain in the United States. Now, one bit of warning, that's not necessarily true in other countries. I did represent an author once whose publisher allowed them to went ahead and published an adaptation of a 1920 book in the U.S., and then they published it in the U.K. too, without anybody researching the public domain status in the U.K. And it was not clearly in the public domain in the U.K. So you do have to think about, if it's going to be published outside of the U.S., and most books are, then you have to think about that too.
And I'll give you one other word of warning, which is just because, it may be a very old work, a Molière play might be public domain in French, but if you're using a translation that's post-1923, there may be a copyright in the translation. So again, it's the underlying work which is in public domain. There might be a subsequent version. Mary and I were looking at this one question, which is one of my sort of a scary one, which is, how much use of song lyrics is fair use in a cultural history book on music? And so these are the types of questions that, often when they would come to me, I'd get another lawyer or two to look at it and say, what do you think of this use? And so the use, what would I be looking for? I'd be certainly looking for context. Yeah. So just by way of example, there was a cultural, sort of a cultural history journal I worked on. And so if you're dissecting the song lyrics to say, this is what Bob Dylan was saying about, the establishment, then, you're going to use as much, you're going to quote as much as you need to from that Bob Dylan song, and as much as you need to isn't as much as you want to, it's as much as you need to. On the other hand, if you're not really commenting directly on that song or that artist, and you're just sort of using it to say, hey, this is what was going on, now you're moving a little bit further away from that comment and criticism area. So again, you have to look at, the songs. I mean, I'm not sure there's any lyrics other than In-A-Gadda-Da-Vida in the song In-A-Gadda-Da-Vida. Maybe there's a lot of them, and maybe that's not the best example, but so if you use that line, how much of that have you used, and how much of it do you need to use? And of course, you can use the song title. So again, these are very hard questions. So with music, the things to keep in mind are, on the one hand, music tends to be a fairly litigious field, yes. And particularly if you're reusing music in music, like sampling, people always get permission. On the other hand, I'm not sure that there's been that much litigation by music publishers against people who are doing, music criticism and music theory. Again, particularly if it's not substituting for the work. So that's sort of the analytical frame through which I would look at this.
Yeah,
Mary, what are your thoughts?
Well, I think that one question to always keep in mind when you're using part of somebody else's work, whether it's a quotation from letters or a poem or lyrics, is, are you using it for the expressive value of the work? And that is, are you taking it because you really like the way it sounds, or you really like it and you think it will add to your work because it's, it's entertaining or interesting or whatever? That's when you're encroaching on it not being fair use. But if you're taking it because you want to put it in historical context, or in the case of a song lyric about cultural history, you're explaining how that relates to the cultural history. That is absolutely fair use, and that's one of the primary reasons for fair use, in fact. So I want to just hammer out a couple other easy questions real quick. Somebody asked, what is the copyright status of an unpublished manuscript that's part of discovery in a lawsuit? If it's not registered, will it lose common law copyright protection? Okay, so under the 1976 Act, every work that is fixed gets copyright the moment it's fixed. And by fixed, meaning for a textual work that it's put on paper, typed, whatever, that it's actually written down somewhere. So there absolutely is copyright in unpublished manuscripts, and no, you do not lose it. There is, in fact, no more common law copyright protection in this country, with the exception of sound recordings pre-1972. So it does not apply to textual works. Okay. There was, I wanted to turn now to, there was a few questions about how to protect your works from use by others, okay? So one question is, somebody's copying my work and selling it on Amazon, and he's from overseas. How do I stop this? And is it fair use, was a question somebody else had. And how do I know if somebody else's use is fair use? So let me take the first one. If somebody's copying your whole work and selling it on Amazon or any other internet platform, the way to handle it is to send them a notice. Amazon is actually pretty good. We have other issues with Amazon and the publishing sphere, but one of them is not that they don't deal with piracy. If you tell them there is a copy of an unauthorized copy of your work that's being sold, and you tell them to take it down, they will. There are forms on their site to do so. If you have trouble finding it, just send an email to staff@authorsguild.org. I don't have the link. I don't know it by heart, but we can easily find it, and we send them notices all the time on behalf of members. Same with if you find it on any other website, on Google, you can send what's called a Section 512 notice. And the internet site is required to take that work down. And we won't go into that in any great detail here. It's the subject of other webinars. There's a lot to be said. But again, if you are, I just want to make sure that's clear to everybody on the line, that if you're an Authors Guild member, you can get legal advice from us. You just send an email to staff@authorsguild.org. Are there any other questions that we've missed here? In terms of figuring out if somebody else's use of your work is fair use, it's the same analysis. Just, are they taking more than they need to make their points? Is it transformative? All of the factors we just went through need to be taken into account.
Yeah, I mean, there's a number of questions. It's all about how do you determine with a small amount, and I don't think we have to answer each of them individually. I think it's all the sort of same analysis, that we've gone through. Two comments I'd like to make, probably because we're running out of time, in closing. One is, since I'm talking to an audience of largely authors, there's a lot to say for the golden rule, do unto others as you would have them do unto you. When we did an event at Book Expo last week, and one of the things came up was attribution. And, attribution is not a requirement of U.S. law, but certainly it's good behavior to attribute someone. And if you imagine someone used a paragraph of something you wrote and didn't attribute it, you'd be a lot angrier and much more likely to assert a claim than if they attributed you to your work and gave you credit. So, all of these are, there's a degree, as Mary was talking about risk, and, risk is, about what kind of thing, would you expect, what is normal human behavior. And so just, again, if I were talking to an audience of, of non-authors who just like to download stuff, maybe I wouldn't give them the golden rule analogy, although I might. But certainly for you guys, think of it in that context. Think of what's appropriate and what kind of person you want to be. I had a torts professor who always used to say, don't tell me what the law thinks, tell me what your mother thinks. And if what you're doing is the fair thing and the right thing, then you're probably okay to some degree. So
I think that's a great note to end on. Very good advice. And if you look at the cases, I actually often think the judges are making decisions based on whether they think it feels right or not, and then they figure out how the factors weigh. So let's end there. And again, if you have further questions, you can always email us. So thank you very much for joining us today, and I want to thank Roy for attending.
Thanks for having me. Bye-bye.
Bye, everyone.